Mr. Goheen Rango, how are you, sir?
Doing well. Good morning, Mr. Wheeler.
I'm doing good too. So
Yeah.
Looks like you had the chance to talk to Ms. Gaffney and your matters are getting set over into January. Is that your understanding, sir?
My understanding was it was going to be pushed out a little bit further. I had something that I was trying to discuss with her. I haven't seen her about any of my matters for several months, so we didn't have the time. We didn't have the time window for that, but I got partly way through it. So there is something that I'd like to briefly address on the record for my sake, Your Honor, to the court, and then I have some questions follow up for Your Honor.
So, Mr. Goheen Rango, if you give me just a moment, sir, I'm going to just get your next date set, and then I'm fine with doing that. So it looks to me like what's proposed is a speedy trial waiver on all three of the cases. The next court date on these matters is going to be on the 27th of March, 2024. That's going to be at 10 a.m. on each one of the cases. And certainly if there's changes in Superior Court or something of that nature, we can always have you come back sooner. Or if you're out of custody, the expectation is we'll be seeing you either on Zoom or in person on March 27th, 2025 at 10 a.m. Is that agreeable to you?
Very good. Yep, I can do that. Thank you.
Okay. Sounds good.
So, Your Honor, may I briefly address the court on the record for my sake?
So what I will tell you, Mr. Goheen Rango, is what I would tell any person. You have the right to remain silent. You've chosen to exercise that right before. If you do have something you want to tell the court, generally attorneys advise folks not to talk to the court directly. But you did do the things that I asked you to do. And I want to respect the fact that you did that. So if Ms. Gaffney does not have an objection, I'm going to hear you. Now, it has to be brief because we are running out of time and you're my second to the last person. But if you want to take 2 minutes and you want to talk to me, that's fine.
Sure, it might run a little bit over. Yeah, I'm actually missing my lunch hour here at the Clark County Jail. So it's okay, I'm fast.
Well, that makes two of us then, Mr. Goheen Rango.
Oh, all right. Okay. And I do have a few questions afterward to follow up. I hope we have time for that too. So the system's inherent prejudice, the system's inherent prejudice against the poor and disenfranchised is making them victims of human tragedies that often result from the bureaucracy's preoccupation with processing cases rather than rendering meaningful family-oriented solutions to social problems. Those less savvy often become lost in a nightmarish maze called social reform within the larger context of social apathy and decay. One problem that I've seen in about 8 years is a prosecutorial misconduct pattern. It's prejudicial error, and I'm working on a referral to the bar and the Department of Justice to initiate disciplinary proceedings for some of these multiple wrongs done to the people. The thing about prosecutors is they have a special obligation as prosecutors, as an administrator of justice and an advocate, whose interest, therefore, is not that it shall win a case, but that justice shall be done. They have a special responsibility, Your Honor, to pursue justice. The Supreme Court itself said prosecutors have an ethical obligation to prevent unfair prejudice, either by accident or by design. Their duty is to seek justice, not merely to convict. They are a representative of the sovereign. The accused is to be given the benefit of all reasonable doubts, and the Supreme Court also said one vision of justice is the appearance in reality of fairness and neutrality, that justice may be achieved by honoring constitutional dictates, particularly in the context of criminal trials. I think it's subsection, I don't know, it's SS 813.02 shows the responsibilities and regulations of prosecutors. A lot of the federal prosecutors have the benefit of a U.S. Attorney's Manual. These public defenders are up against prosecutors that don't go by the U.S. Attorney's Manual per the federal standard. But the long and short of it, I know my rights are being violated. I was in 3 years of AP government politics in high school, where I was put to the top of my class and voted by teachers and my principal, selected out of 300 graduating people in my class to go to Evergreen Boys State, where I was given awards of excellence there as well. So my questions for your honor today and to the court, on the record for my sake, so I can come back to this and find these minutes one day when I'm older and wiser. Is it lawful to punish a natural-born United States citizen for any crime before he or she has been lawfully convicted of the crime? Is the first question. Is it lawful to punish a natural-born United States citizen for any crime before he or she has been lawfully convicted of the crime?
Yeah, so I've given you the 2 minutes and I'm fine with answering the question. You know, I think I'll try to look at the camera rather than look down, but you have to understand you're down and I understand that I'm up. So I'm going to try to make eye contact with the camera. You know, it depends on the definition of punishment. Now, certainly as a judicial officer, one of the things that we're required to do is, of course, hold that presumption of innocence. I think that the challenge in doing that, and I understand why we're kind of washing towards a line of punishment, is when I set release conditions, let's say on a case that says no law violations, and the person comes back and there's an allegation they violated the law again. And you've seen me plead in court before, and I've set the person out again and say, okay, no more law violations. And the person comes back for the third time and there's another law violation. And I say, pretty please, no more law violations. And they come back and there's a fourth law violation. Now, at that stage on that fourth law violation, let's say I choose to take the person into custody. Now, you might say, Judge, you just punished that person, right? You're depriving them of their liberty. And I think that always my perspective is I'm going to do everything I can before I have to do anything that appears to be punishment, because you are correct in terms of a person not being punished without disposition on their case. Where that punishment slides into community safety, though, is when that person who's been drinking and driving now 4 or 5 times in a row, we know your mom is out in the community in La Center and is drinking and driving and endangering your mother on that 4th or 5th DUI. So is it punishment? It is certainly deprivation of liberty. Is the court able to do that in the overall arch of community safety? And I would say yes. So it's a nuanced question you asked. I always appreciate you, Cleve, because you do bring up good salient points. This is all the time I have for today, though. And again, I do appreciate your comments and questions. And again, I want to provide you. You were respectful to me. I will always be respectful to you.
Thank you.
Thank you.
Yeah, I try to be respectful to everybody, and I probably fall pretty short of that. You guys have a great responsibility, and for what it's worth, it's kind of a special time in my life to see. It's a window, and it's not like TV shows and stuff. And I do appreciate everybody. I just want to get through this all in one piece. So.
Thank you.
Thank you.
Everybody. I appreciate your time today, sir. All right, so we're gonna go now. Are we ready on Mr. Briggs, Mr. Cheney?
Yeah.
Okay, and I'm just gonna ask you to tilt that microphone towards you or come up here just so Mr. Briggs can hear you.